and another.
Yes, Mr. Barrow.
I'm grateful. My Lords, if it pleases, I appear with my learned friend Dr. Darby for the appellants who are the claimants below, and whom I will call Athleta. My learned friend Mr. Van Hagen leads Dr. Muir Wood for the defendant respondents, and I'll just refer to them compendiously as SGD, because I don't anticipate in my submissions that I will need to distinguish between the defendants. I hope that my Lords have received a skeleton from each of us, and an updated schedule to my learned friend's skeleton on Friday. I'm grateful.
Thank you.
Then a core bundle and 2 supplementary bundles and 2 authorities bundles, I hope.
That's very helpful, thank you.
I'm grateful. I have a lot to get through in a couple of hours, but I will do everything I can to make sure that I keep to the timetable that we submitted to my Lord yesterday.
That clock is about 2 minutes slow, but I don't think it'll matter.
My Lord, if we're within 2 minutes of precision, my estimate, I consider myself to be doing very well.
Very good.
This is an appeal. I'm going to set the scene very briefly. This is an appeal from a decision of David Stone in the High Court, as my Lords are aware, following trial of an action for trademark infringement and passing off, in which Athleta relied upon 2 registered trademarks, which the judge correctly set out at his paragraph 4. I will call them by the same names that he did, namely the Athleta word mark and Athleta combination mark, and the latter, of course, is so called because it comprises a combination of a word element with a figurative element. We will deal in particular during the course of arguing ground 1 on genuine use in some detail with what it is that we say Athleta sold, but for present introductory purposes, I think it's fair to say that the dispute as a whole has centred on the sale of clothing, footwear and associated accessories like headgear and bags. Both the registered marks relate then to the appellant's brand Athleta, as well as the registered marks, for the purposes of its unregistered rights in the context of the passing off case, Athleta relies upon what we say is its goodwill in the 4 signs that the judge correctly set out at paragraph 5, which is on page 109 of the bundle and across onto 110. As you can see there, he gave the latter 2 of those names, and I will use the same names that he did for those 2. These are all rights, we say, that Athleta owns around the brand Athleta, and this dispute is about SGD's use of its brand Athlecia. Under his paragraph 6 on page 110, the judge sets out the Athlecia signs that we complained of, giving them names which I, again, will use. And he records at 7 that SGD admitted it used those signs in the UK in relation to bags, clothing, headgear and footwear. So there was no dispute really about what acts SGD had done in fact. The dispute instead was about whether those acts comprised infringement and or passing off. Now, to be clear, trademark infringement was argued only under section 10.2 of the Trademarks Act. I'm not going to go through that in any detail, but for my Lord's notes, it's set out by the judge correctly under paragraph 105, which is on page 139 of the bundle. So we're talking about infringement on the basis of similar marks and similar goods, such that there exists a likelihood of confusion on the part of average consumers between the mark, that is, the registered trademark sought to be enforced, and the sign, that is, in this case, the respective one of the Athlecia signs used by SGD. Then at paragraph 9 on page 110, the judge sets out SGD's essential position, framing the issues in dispute. Athleta has grounds of appeal today going to number 1 and number 2, so that's to trademark infringement and to passing off, and to number 4, which was the revocation for lack of genuine use. On this appeal, my Lords, you don't need to be concerned with number 3. SGD ran 2 invalidity attacks against both of the registered trademarks. Those failed in respect of both marks, and SGD does not seek to rerun them on this appeal at all. The judge set out the agreed list of issues at trial then in paragraph 11, and in his conclusions, in the final paragraph of the judgment, he expressed the summary of his findings as a series of answers to those issues. So in short then, aside from those dismissed invalidity counterclaims, the relevant findings of the judge are as follows. First, under genuine use, he found that there was genuine use of the Athleta word mark in relation to bags, clothing and headgear, and that there was genuine use of the combination mark in relation to clothing only. On trademark infringement, he found no infringement of the word mark and infringement of the combination mark by the second Athlecia combination only. That's the one where the roundel is in line with the word Athlecia. And my lords can see those in my skeleton, those different signs in my skeleton at paragraph 5, which is on page 40 of the core bundle. The Athlecia signs there are on the right, and it was the second Athlecia combination which the judge found to infringe the combination mark. Importantly, he found no infringement of the Athleta combination mark by the first Athlecia combination, where the roundel appears above the word element. So we say, somewhat surprisingly, we say, given the very small difference between them, the judge found, looking at those last two marks on the right-hand column, that the last one infringed, but the second last one didn't. And you'll hear more about that from me in relation to grounds 4 and 5. Finally, on passing off, the passing off claim was dismissed. So just to explain the shape of the appeal before getting into the grounds, we appeal on grounds in relation to each of those three heads of dispute that I've set out. Ground 1 has two parts and relates to the genuine use findings. With my Lord's leave, in light of the Lady Chief Justice's recent guidance, if it pleases my learned junior, Dr. Darby will deal with ground 1 when I've concluded this introduction, and then I will take on the remaining grounds.
Yes, certainly.
I'm grateful. Ground 3 then relates to infringement of the Athleta word mark, and in particular the judge's approach to the similarities of the respective marks, and in part the role of distinctiveness where the mark has a portion that is elusive. Grounds 4 and 5 I will take together. They relate to the findings in relation to infringement of the combination mark, and in particular what we say is the anomalous conclusion that the mere movement of the roundel from one side of the word through 90 degrees to another side of the word took Athlecia's use out of the context of trademark infringement. Finally, grounds 6 and 7 also go together as a pair and relate to the passing off allegation. In relation to those, I need to succeed on both. I'll explain that when we get there. An important point to note further is that there's no respondent's notice. And so all the findings that the judge has made in Athleta's favour, the dismissal of the invalidity claims and the findings of trademark infringement that he has made, are all unappealed and will not change in light of my Lord's judgment. In that sense, Athleta's appeal can't, by its position, can't by this appeal go materially backwards. And one aspect of the significance of that is that when we come to look at the infringement findings in relation to the Athleta combination mark, part of the analysis in relation to infringement by the first Athlecia combination can be addressed starting from the fact that it's effectively agreed that the second Athlecia combination does infringe. So we will, as part of the analysis, look at the difference between those. That can't be all of the analysis, and I don't suggest otherwise. But we will look at the difference between those when we ask whether the judge's approach was wrong in principle when he compared them and decided that they yielded different answers to the infringement question. My Lord, with that very brief introduction, if it pleases, I'll propose to hand over to Dr. Darby to deal straight away with ground 1.
Thank you. Yes, Dr. Darby.
Thank you. So as a preliminary point to ground 1, I'd just like to refer to the respondent's skeleton. The respondent, we don't need to turn it up, the respondent at paragraph 5a made the point that whatever happens in relation to ground 1, it will not change the infringement findings based on the pleadings, just to say that we accept that. And so ground 1 is all about whether we can get certain goods back for our marks. It's not about the infringement aspects. The second point I'd just like to make as well is that we, contrary to what we said in our skeleton, we will only be seeking to reverse the judge's findings in relation to the Athleta combination mark when used for bags and when used for headgear. So we are not going to seek to alter the judge's findings in relation to footwear or clothing accessories for either of the marks. Okay, so with that introduction, I will now follow through the logic of our skeleton in my submission. So starting in our skeleton at internal page 4, which is bundle page 42, here we start with ground 1 and we lay out the statute that's relevant for genuine use. Genuine use is a use it or lose it provision, So if you do not use your registration in a period of 5 years, then it's liable to be revoked. For your Lordship's note, in relation to the relevant 5-year period for this judgment, that is the 12th of July 2017 to the 11th of July 2022. And that is recorded in the judgment at paragraph 66 and 67. Another point to make about this provision is that a variant form of the sign that's registered can support genuine use of that registration. And in that regard, the judge found that the Athleta dark pinwheel was a variant form of the Athleta combination mark. So when we're talking about genuine use for the Athleta combination mark, use of the Athleta dark pinwheel is relevant and supports genuine use for that registration. That's recorded in the judgment at paragraph 72. Now moving on in our skeleton to internal page 5, that's bundle page 43. We lay out at paragraph 9 a summary of how you apply the provisions for genuine use. That's a summary from your Lordship, Lord Justice Arnold, in Easy Group Limited and Nuclei Limited. Your Lordships will want to have this in mind for the assessment, all these points in mind, but I'll just pick up some of the points right now. At point 2, we're told that the use must be more than merely token, and so a token use which is just to solely preserve the rights conferred by the registration does not count as genuine use, so it has to be beyond that. Turning over the page to point 5, we're told that the use must be to create or preserve an outlet for the goods or services that bear the mark. So that's what we have to establish. Is it a use which will create or preserve an outlet for the goods or services? Point 6, just to highlight that it's all the relevant facts and circumstances that must be taken into account when you're determining whether there's genuine use. And point 7, that use of the mark need not always be quantitatively significant for it to be deemed genuine. So there's some principles I just wanted to highlight as we go through. Obviously, all of them have to be borne in mind. So when you have genuine use that's put into issue, then the burden is on the proprietor to prove that genuine use. So that's what we had in this case. And it was on Athleta to provide evidence of genuine use in that relevant 5-year period. And Athleta provided some evidence in the form of its website, some screenshots of that. Now at that stage, I think it's worth just looking at a sample of that evidence. So if I may direct your Lordships to supplementary bundle 2, it's bundle page 98. So here, are your Lordships there? So supplementary bundle 2, page 98. Go here, so we have one example of the screenshot from the Athleta website. We can see the Athleta dark pinwheel at the top. That's the variant form that's relevant for the Athleta combination registration. We also see the label of all accessories, and we have a hat and a bag there. So obviously what I'm speaking to today is whether there is genuine use in relation to headgear and bags. So we can see some headgear and bags in that image. Now, as is always the problem with Wayback Machine, it doesn't always record all of the aspects of each website, so we see a lot of grey boxes there showing that it didn't record all of the products under that title. So if we go back in the bundle to page 90, you can see more of a selection of the kind of goods that were offered on the Athleta website. Again, Wayback Machine's not recorded all the images, but we can also look at the descriptions of the absent images to see the kind of products that were there. And we can see there are hats and various bags, crossbody bags, tote bags. And if we scroll through to bundle page 91, there's more bags there in images and in description for absent images. And then moving on to bundle page 92, we have some headwear. We have the images for a headband and the hat again. We also have the description there of baseball caps and running caps. So we can see there is a variety of products that fall into the categories of headgear and bags that were on the Athleta website. So now this is the evidence that was submitted during trial for the Athleta website. Now just to look at how the judge analysed this evidence, may I now direct your lordships to the judgment. So this is in the core bundle at tab 9, bundle page 128. So at bundle page 128 we have the subtitle Use on US Website, and if I can just ask your lordships to read paragraphs 52 to 54, and then I'll make some submissions on that. Okay, so as we look at the beginning of this section at paragraph 52, we see that the judge was quite happy that the Athleta website showed activity for the Athleta brand in the US. So the question he was wanting to ask himself was, is this relevant to the United Kingdom or the European Union? And that's the question for whether this was genuine use in this jurisdiction. At paragraph 53, he then sets up the framework which he's going to use to make this assessment. And that framework is that of targeting. So he's going to see if that website targets the UK. He correctly identifies the Supreme Court's judgment of Lifestyle Equities and Amazon, and he is then going to use those factors to assess whether the website targets the UK and thus whether it represents relevant evidence for genuine use.
Can you just help me on this? You referred, as does the judge, to the EU. I'm a little struggling to understand the relevance of the EU, given that the registrations relied upon are UK registrations. So what's the relevance of the EU?
So it's because it spans, the relevant period spans the end of the IP implementation period, sorry.
So what?
And so there were comparable marks, I believe, coming from European registrations.
Oh, these are originated as EU registrations.
Indeed. So then
Okay,
what that means is...
that's not something I picked.
Okay, so then EU is relevant prior to 31st December 2020,
Right.
and then it's UK only after 31st December 2020.
Thank you.
Okay, so...
May I just ask?
Yes?
Wasn't entirely clear to me from your skeleton, but are you accepting that the approach the judge took of relying on the lifestyle equities factors is correct in this context?
Yes, so it's slightly mischaracterised, I would say, in paragraph 54, but our position at trial and here is that we accept that that framework is a legitimate framework in which to assess whether the website was targeting the UK and also to thus assess whether there was genuine use based on that website. We do accept that. And so, yes, that's paragraph 54. So the question is then to look at lifestyle equities and consider what factors it says are relevant and see how the judge utilised, or in our submission, did not utilise those. So if we go back to our skeleton, that's now bundle page 45. We've here laid out some quotes from lifestyle equities, which we say are relevant to the consideration. At bundle page 45, at paragraph 12, we state the quote where the Supreme Court is agreeing with the propositions it has put higher up in the judgment. That's just for completeness, because that means they agree with the quotes we have put in paragraph 13 and 14 of our skeleton. Okay. So now at paragraph 13, just some factors I want to highlight which the Supreme Court agreed were factors which would indicate targeting of the UK. So in paragraph 13, in the quote about halfway down, just want to highlight use of a language or a currency other than the language or currency generally used in the member state in which the trader is established. That would be an indicator that the website targeted the other territory. Another one is the mention of telephone numbers with an international code. That would be considered to target another territory. Turning the page in our skeleton to paragraph 14, this is a particularly important factor because in the quote itself it says this is a particularly important factor when considering targeting. It says, where the offer for sale was accompanied by details of the geographic areas to which the seller was prepared to dispatch the product, this kind of detail would be particularly important in the assessment. So that's important to bear in mind. It's said by the Supreme Court to be particularly important. In our submission, that was not taken account of by the judge, and we'll see that in a moment. At paragraph 15, this is just a reference from the Supreme Court that the subjective intention of the seller can be relevant when looking to assess whether there is targeting of the website. Now, these are the factors which Lifestyle Equities said should be taken into consideration. I'd also like to just highlight in Lifestyle Equities itself some factors which are considered of minimal relevance. So if I may direct your lordships into the authorities bundle, the first authorities bundle, and this is tab 8. First authorities bundle, tab 8, and the bundle page is 236. And if your lordships at page 236 could please read paragraph 78. And I'll make a submission on that. So in paragraph 78, we have the analysis from the Supreme Court that said they would place very little weight on the UK sales from Amazon versus the US sales. And that makes sense for the reasons they've given, that if the average consumer is interacting with the website, they have no idea about these relative sales. So it's not a factor that will influence the targeting assessment. It also makes sense because it's not actually an indication of whether a website is targeting UK, it's just an indication of the success at the targeting. So when you're looking for the fundamental question of was it targeted, the actual sales is not a factor that you should place a lot of weight on. So then moving forward in Lifestyle Equities, we can go on to bundle page 238. Bundle page 238, right at the top of that page, we have Roman numeral 2. And here the Supreme Court is saying that it was an error of the judge in this instance to treat the fact that a website is primarily targeted at one territory as a weighty factor towards a conclusion that it is not targeted at one or more other territories. So again, just because a website is primarily targeted somewhere does not negate the fact it can be targeted at other territories as well. So I'd like to bear all those factors in mind as we now move on to look at what the judge actually did when assessing targeting. So if we may go back into the judgment, if we may direct your lordships to bundle page 134. So this is in the judgment, bundle page 134 of the core bundle, paragraph 74.
Sorry, paragraph
74. So here at paragraph 74, we have the judge performing his analysis on the Athleta combination mark in relation to bags. So he's assessing here whether there is genuine use of the Athleta combination mark for bags. Now what I would like to pick up in this paragraph, so we go 5th line down, starting at the end of the 5th line of paragraph 74. It says there is use of the Athleta dark pinwheel on the Athleta US website in relation to various bags. So the judge there is noting there is use on the website in relation to bags. Why does he not find genuine use? Well, he goes on and says, however, the website is primarily a US-facing website, not primarily targeted at UK-EU consumers. Now, we've just seen from lifestyle equities that is a factor that has not much weight, according to the Supreme Court, but that seems to be a factor that the judge is taking into account here. He goes on in this paragraph, and it talks about the comparatively low value of the goods and the fact he would expect to see lots of sales. And he says, moving on, the evidence was that it was possible for a UK EU customer to buy the Athleta branded bags offered on Gap's US website, but the evidence showed that very few customers actually did. Now, also, as we saw from lifestyle equities, the scale of the sales is not a factor which should be given much weight. And so, in the totality of his assessment, the judge has taken into account two factors which were considered relatively irrelevant by the Supreme Court. And he has taken in no other factors which we say are present in the evidence and which are material factors he should have taken into account according to the Supreme Court. So I will go on to explain those particular factors in a moment, but just to move on while we're in the judgment to the next page. So this is page 135 of the bundle. And here we have the section on headgear. That's the other finding that I'm seeking to change. And paragraph 77 is where the judge again refers to the absence of any significant sales. That's what he says in paragraph 77. So yet again, he is focusing on the scale of the sales rather than all the factors he should be considering to find whether the website targets the UK. This is an omission of the material factors he should be taking into account and the taking into account of irrelevant factors. This justifies appellate interference in these findings.
He put the word significant in brackets. Is that significant? Don't we have to read these passages as a whole? For example, paragraph 77 also includes the sentence in the second line, no compelling evidence of sales into the UK. And I'm not going to fall into the trap of taking isolated words or phrases out of context. But my point is, don't we have to read the whole of that passage?
Indeed, yes, and that is aligned with my point that he is taking into account the level of sales. That is what he is saying in this paragraph.
Right.
And so,
similarly, on the previous page, you stopped citing halfway through paragraph 74. But don't we have to take into account what the judge proceeded to say in the middle of that paragraph? There was no evidence before me, ... Now, I stress, I'm not going to fall into the trap of only taking one or two sentences out of context.
Yep.
But isn't the point that we have to read everything?
oh,
as a whole?
indeed. I mean, with the limited time, I'm trying
No, I
to
understand.
yes,
Right. I understand.
jump through, but definitely yes. No, you have
All
to
right.
take everything in
All
the
right.
context there. But I'm saying we can see what were influential and the factors he took into account. We can also see a lack of the factors he should have taken into account.
Right.
And those factors he should have taken into account, I'll now go through. So if we return to the skeleton argument,
Just on paragraph 74, just since my lord was on it. 8 lines up. Should that say purchase rather than produce?
that
that
is
common
my
ground?
interpretation, indeed.
Right.
Right. Okay.
So returning to the skeleton argument for the factors that he did not take into account. Paragraph 16 of our skeleton, we lay out these factors, and the first one is the fact that the UK and the EU member states were included in a list of geographic areas to which Athleta was willing to dispatch the product. Now, to keep things quick, I will just give you the references for this evidence rather than taking you there. So that evidence is at the supplementary bundle, the second supplementary bundle at tab 4, starting at page 67. Following that through, you can see that the person interacting with the website is given information about shipping, and they are able to, through that information, pick Europe as a region to ship to, and in particular the United Kingdom as a region to ship through. They're able to put the currency as Great British pounds, and they are told that with that information they can ship from the Athleta website. That is what is said in that evidence there. So those are the important factors identified by the Supreme Court, the places where the website is willing to dispatch its products. And the evidence demonstrates it's willing to dispatch it to the UK. There's also the mention that a subjective intention is also potentially relevant. There was a subjective intention in the evidence. We have in the supplementary bundle, the second supplementary bundle at tabs 1 and 2, again, I don't intend to take you there, but at tabs 1 and 2 there are agreements between Athleta and a third party to ensure that they provide shipping to the UK. So that was the intention of Athleta to have that. And also that's described as well in the witness statement of Sarah Nichols. Again, I won't take you there, but for your note, that's at the second supplementary bundle, tab 11, starting at page 174 as well. So these are relevant factors which should have been taken into account by the judge. They were not taken into account. In relation to intention, a further point is that we can see from Athleta's operations afterwards that they then went on to sell products via John Lewis and via Zalando. So that's recorded in the judgment at paragraph 63. I suggest that because they carried on trying to establish this market in the UK, we can see that as further support that it was genuine use with the website. There was a genuine desire to create a market in the UK, build a market, and that's what they carried on trying to do via John Lewis and Zalando. We can see that they tried to do this with bags and headgear. Just to make clear, that's bags and headgear. Again, I'll just give you the references for the evidence. In the first supplementary bundle, pages 145 to 148 is a list of products that were supplied by Athleta to John Lewis. It includes tote bags, it includes headbands. So they are continuing with these products to try and maintain or build a market in the UK. The sales are also given in bundle pages 184 and to 191. Worth noting as well, as Zalando also sold headbands, the evidence for that is at the second supplementary bundle, pages 183 and 186. 186 also shows the dark pinwheel, which is relevant for genuine use of the combination mark. So that's the targeting aspect. There was a second aspect to this ground of appeal, which was the fact that we say the judge used a de minimis rule when making this assessment. That's implicitly come into my previous submissions, and the fact that he took sales into account, and for targeting that's not meant to be the case according to lifestyle equities. But just to make good, that is also for genuine use per se. If I may direct you to a general court judgment, that's the LG Electronics judgment that's in the second authorities bundle. And so the context of this will be given by Dr. Barron later, as he will also be going to this, but I just want to extract one principle from this. So it's the second authorities bundle at bundle page 199. And so this is a post-Brexit general court judgment, so it's not binding, but we say it does demonstrate the proper analysis of genuine use. At paragraph 55, page 199. Page 199, at paragraph 55, it says, in interpreting the concept of genuine use, account should be taken of the fact that the purpose of the relevant applicable provisions is not to assess commercial success or to review the economic strategy of an undertaking, nor is it to restrict the trademark protection to the case where large-scale commercial use has been made of the marks. We submit that that's the correct analysis. The General Court has done that based on pre-Brexit case law that follows in that paragraph. And so the focus should be on, was there genuine use? Was there attempts to build the market? Not was it successful? Did they adopt the right strategy? That's a different analysis. That's not the correct analysis. So taking the correct analysis, we say that there was evidence of genuine use in relation to those marks. So in summary, what we've gone through is that the judge took into account irrelevant factors when making the assessment. That was the size of sales and the primary territory of the website being the US. he failed to take into account the relevant factors, which were the geographic destinations to which the products would be shipped, the currency options presented, and the subjective intention of Athleta. And so if he had not made those mistakes and done a correct assessment, that would demonstrate that there would be targeting and genuine use in relation to the Athleta combination mark with bags and the Athleta combination mark with headgear. Those are my submissions on ground 1. Unless I may assist you further, I will pass over to Dr. Barron.
Thank you very much. Yes, Mr. Barron.
Ground 3, my lords. This is the ground that goes to infringement of the word mark. I apologise if I'm speaking a little quickly. My lords will understand why. If I become unclear or too quick at any point, I'm sure my lords will just say so. This ground is dealt with at paragraphs 31 to 39 of Athleta's skeleton argument, which I don't propose to turn up. Centrally to this ground, we're looking at the comparison between the word Athleta and the word Athlecia. Though this ground is only about the word marks, the judge has structured his judgment, and this is no sort of a criticism, by starting off with elements common to all of the comparisons he had to do. So I'm going to take you through the shape of that analysis in some detail under this ground, in the hope that I'll be able to be rather quicker when we get to grounds 4 and 5. Trademark infringement under section 10.2 requires an assessment comprising several parts, which are set out in the Musmatch case, as the judge correctly cited under his paragraph 106, which is on page 139 and 140 of the bundle. Could my lords just read that quotation, please? The one bridging pages 139 and 140. So there's a series of 6 factors there, and as the judge rightly points out in the following paragraph, only factor 4, similarity between the mark and signs, and factor 6, the likelihood of confusion, were an issue before him. In relation to requirement 5, as explained at 108, SGD accepted it had sold goods not just similar, but in some cases identical, to goods for which both marks were registered. As to the last of the 6 Musmatch stages, the analysis of likelihood of confusion, that requires a global assessment of all the relevant factors. And the other thing to emphasise about the approach to the likelihood of confusion generally, which I understand also to be uncontroversial, is that an interdependency principle applies. That much is well established and uncontroversial on this appeal. All it means is that there isn't some threshold value to be met in respect of each input into the assessment. Rather, the assessment is in the round, so that a factor which on the facts points very firmly in favour of a likelihood of confusion may offset another factor which does so less firmly. All points away. In that context, the fact we have some identical goods is an important element of the assessment. Identity of goods, which we might think of as sort of infinite or 100% similarity, may offset other factors in the assessment of the likelihood of confusion that point less strongly. The judge then briefly set out the law on similarity of marks and signs at 110 to 112. I take no issue with it, so I don't propose to say any more about it. At 113, then on page 141, the judge correctly sets out the pairs of marks and signs he's to compare and starts with the visual similarity of the word marks at 114. At the end of 115, on page 142, we have his finding in that respect. Visually, the word marks are highly similar. After that then comes the oral similarity, and at paragraph 119, the judge records the various submissions made about how the marks and signs might be pronounced by UK consumers, and finds, correctly in my submission, that he didn't need to choose between them for the purposes of this analysis. So in the last 6 lines, he gives his conclusion, last 6 lines of 119. It seems to me that whatever the pronunciation adopted, in each case, the mark and sign are highly hourly similar. On all rival pronunciations, the first syllable, the most important, is identical. The difference in pronunciation between li and le, and so on and so forth. So the conclusion is highly hourly similar. Finally, we reach conceptual similarity, and after recording the submissions made, the judge reaches his conclusion in the last line of 120 that the marks are highly conceptually similar. So having done that staged assessment of similarity of aspects of the signs, the judge returns to consider their similarity in the round, and therefore finds, perhaps inevitably, at paragraph 121, that the word marks in total are highly similar. So far, in respect of two central comparisons that are inputs into the likelihood of confusion assessment, we have more or less the highest available scores on an assessment under section 10.2. The judge has confirmed total identity of goods in respect of SGD's sales of clothing, and similarity to clothing in respect of bags, headgear and footwear, and also highly similar signs because they were all three of highly visually, aurally and conceptually similar. So far then, everything is pointing very firmly in favour of the likelihood of confusion. Next comes that global assessment of the likelihood of confusion, and the judge at 125 sets out a summary of the relevant principles coming from this court's judgment in Specsavers. That was and is uncontroversially the right summary for the judge to have set out. I'll just pick out two of the factors for present purposes, if I may. C, the average consumer normally perceives a mark as a whole and does not proceed to analyse its various details. And so implied as part of this instruction, as part of this, is the instruction that the court should take the same approach, since the assessment of similarity is all through the eyes of such an average consumer who doesn't tend to microanalyse bits of the mark at a time. G then, a lesser degree of similarity between goods or services may be offset by a great degree of similarity between the marks and vice versa. This is just a particular manifestation of the interdependency principle I referred to before. The average consumer in this case was agreed, and there's no dispute about it on appeal. She's an ordinary member of the public. The section of the judgment on assessment of the likelihood of confusion starts at 134. It's on page 148. First, the date for the assessment was the date of commencement of the alleged infringement, and again, there's no controversy there. The date was the 30th of November 2021 in this case. At 136 and following, still on page 148, before tackling the global assessment on the facts, the judge dealt with some preliminary issues on the evidence. So first, at 136 to 139, the judge discusses certain evidence about dictionary definitions and use of certain signs which were neither Athleta nor Athlecia that had been adduced by SGD. This evidence occupied a decent chunk of time at trial, but ultimately the judge found it to be of no assistance. So we can leave that on one side. The second point then is at 140. SGD had relied upon a Court of Appeal decision recently handed down, in the lifestyle equities litigation. The judge agreed there with my submission that that judgment didn't assist him, but the reason for that's important, so I just want to pause here very briefly. He found that that lifestyle equities decision was of no assistance because that was a decision concerned with what happens when there's a crowded market of marks, all with some element in common in that market. So the idea, in essence, is that the distinctive power of a mark beginning, say, XYZ, may be said to be reduced if the evidence shows that lots of brands in that particular market tend to have names beginning XYZ. The judge found that this judgment didn't assist him because on the facts of this case there was no or insufficient evidence for him to make a finding that there was such a crowded market. So this was not a case about crowded markets like that lifestyle equities decision he refers to there. At 142 to 143 then, the judge also dismissed as irrelevant certain other factors we'd relied on about SGD's intention and behaviour and found that there had been no actual confusion. I don't quibble with those paragraphs either. Finally, well not finally, but finally on this part, at 1848 to 153, the judge assessed certain aspects of the evidence as to the context in which the allegedly infringing sales were made. He found that whilst it was right, he had to have regard to that context. These particular aspects didn't assist him or move the dial to a meaningful degree, so I propose to say no more about them either. The same goes for paragraphs 154 to 155, where the judge correctly records some cases that were put before him, but which I can leave on one side. So next then, from 156 on page 154, comes an important section for this ground, under the heading Distinctiveness of Athlecia and Athleta. The judge starts with a correct quotation from this court's judgment in Lifestyle Equities, I don't quibble with this as a statement of law. I can't. It's a binding Court of Appeal decision, and I don't need to anyway. But can we just look at, could you just read paragraphs 38 and 39 in that quotation, please? Next comes the judge's central analysis coming to this. He says, in fact, if you could read 157 to 159, actually is quicker than me reading it to you, I think. So I'd just like to make some submissions about 159 in particular. The judge says, the case law makes it clear that the distinctiveness or otherwise of the marks is a factor to take into account, and so I must do. I don't quibble with that. In the words of my Lord Justice Arnold in Lifestyle Equities, and then it says, if the only similarity between trademark and the sign is a common element which has low distinctiveness, that points against there being a likelihood of confusion. The common element may have low distinctiveness because it's descriptive or elusive. In my judgment, that is the case here. The common element singular between Athleta and Athlecia is Athle. And he goes on. To put it shortly, my central submission on this ground about the judge's error is that this assessment of the influence of distinctiveness was wrong because it is just not the case that the only element of similarity is the common element which has, on his findings, low distinctiveness. First, as a preliminary observation, the judge had already found, as I showed you a moment ago, that this was expressly not a crowded market case where the evidence showed a market that had lots of Athle formative marks. He expressly rejected that, so that's not part of the analysis here, that's not what he means. It's just referring to the element in common between the two, Athle. The second observation is that Athle is itself not a descriptive element. On its own, it's meaningless. It is elusive, we accepted that below, and I don't seek to resign from that acceptance. But third, and most importantly, it's simply false to say that the only element of similarity is the Athle element at the starts of the marks, and the judge had found that it wasn't, as I will shortly show you. Both marks are words of very similar length, as the judge noted at 115, if we could turn that up, which is on page 141 over to 142. In fact, it's at the top of 142. Athleta and Athlecia consist of 7 and 8 marks, respectively.
7 letters, yeah.
Sorry, I had to misread that, apologies. They also clearly end identically, with a terminal A. There is similarity at both ends of these marks, in marks that the judge found that would be perceived as being, to all intents and purposes, the same length. As the judge himself put it in that paragraph, at 115, the first 5 and the last letters are identical. He goes on in the course of addressing the visual similarity here at 115 to say that particular emphasis is typically placed on the start of marks. That's fair enough. But then when we get to the assessment of likelihood of confusion, we can go back to 159 on page 156. The judge expressly found that, that because of the Athle element, the average consumer would pay close attention to the suffixes of the 2 marks. And yet he found that the only similarity was the common element of Athlecia because it was elusive by ignoring the suffixes of the two marks, which he had already found were in fact identical. So when he says that is the case here, that the only element of similarity is the common element, it's simply wrong. The suffix, and it's one to which the judge has expressly found the consumer will pay particular attention, ends identically. The judge has just left that out of account when doing the likelihood of confusion analysis.
When you say it ends identically, you mean the letter A?
The letter A, yes. It was a very short mark, so we've got five letters at the beginning, but they've got the terminal A and the same length. He says essentially the same length because the consumer wouldn't necessarily perceive the difference between 7 and 8 letters, you'll recall from 115. So when he says the only element of similarity is the Athlecia bit, it's just simply wrong. He finds simultaneously that the consumer will pay particular attention to the suffix, and then he ignores the similarity in the suffix. In my submission, that's inconsistent. That gap in logic makes this reasoning wrong and appropriate to be reversed. And my lords, we're almost done with ground 3 because that really is the central submission. But just before I move off it, I'd just like to take a few minutes to show you a case, a judgment of this court, which will help us with some principles that show this is exactly the sort of thing that is a sensible basis on which to reverse the judge where they've made this sort of mistake. Not the same mistake, and I'm not making that submission. I'll explain to you when we get there. Could you take up the TVIS case, please? Tab 10 of the First Authorities Bundle. And while my lords are getting that, I'll say this was a case about, I can quote from my Lord Justice Arnold's very first sentence in it, about whether the sign pet shore, used in relation to pet insurance, is confusingly similar to the trademark vet shore, registered for the same service. So each of the marks at issue was a combination of elements with a degree of meaning to each, and there was nothing else in the mark. The infringement was pet shore, that is pet plus shore, for insurance for pets. And the registered mark was vet shore, so vet plus shore, for insurance for pets, namely insurance to cover your vet bills. Now, on appeal, it was ground 3 in this decision that went to the judge's assessment of distinctive character. If my lords could please read paragraphs 42 to 46, which start on page 280 of the bundle, then I'll make some submissions about them. The first point that I wish to make is an overarching point that it's wrong for my learned friend to say this is all just a matter of appraisal and my lords can't and shouldn't go behind the judge's assessment where he's analysed the influence of distinctiveness here. This is a case, TVIS, where the court did precisely that and reversed that sort of finding, and it did so because the judge had made a mistake and gone wrong. So he has here, he's relied on something that's simply not true, on his own findings. Second, I say fact matching isn't terribly helpful, but just to show you that this isn't very easily distinguished so that the principle here that I've just explained can apply, there are several elements of the analysis here that will strike right away as being very closely analogous. Athleta is also an invented word. It doesn't appear in any dictionary. Athleta is not an element which is descriptive. Those are all elements of the reasoning that you've just read from my Lord Justice Arnold. Next, there's the observation the court makes in TVIS at paragraph 43 that you've just read, that the judge below in that case appears to have assumed that a mark composed of descriptive elements must itself be descriptive, and that even that's wrong. So even when you've got just descriptive elements and nothing else, the overall effect is not necessarily a descriptive mark, because the mark must be viewed as a whole. On our case, the facts are slightly better, we would say, because Athleta as a whole is plainly not descriptive, as the judge had correctly found when he dismissed my learned friend's counterclaim. As for the elusive element, Athleta, like in Vetshaw, it's not an element that must directly and inevitably allude to clothing, insofar as it conjures up a thought about athletic properties of something. It doesn't directly point at clothing, which is something else my Lord Justice Arnold relied on in the Vetshaw case that reads across. Nor is the mark, in our case, Athleta, as a whole, purely composed of elusive elements. You've just got pet and shore, or vet and shore, in that case with nothing else. It's not the case here. The only element where the judge says the distinctiveness gets downgraded is part of the mark. So returning to our case, the judge should have found that even where the beginning of the marks comprised an elusive element in Athleta, that wasn't the only point of similarity of the marks. There was also the shape, by which I mean sort of the length effectively, and the ending of the words as points of material overlap. And in a short mark, that makes a difference. So the assessments of distinctiveness here wouldn't point strongly away from the likelihood of confusion on the lifestyle equities basis, because the condition precedent there, if the only element of similarity is, simply isn't present. To that, of course, in the likelihood of confusion, we must add all the other factors that all point strongly in my submission the other way. Identical goods, and some similar goods, and the high similarity of the signs on visual and oral and conceptual bases. There were no other factors that the judge had or took into account that pointed away. The only factor he assessed which pointed at all away from the likelihood of confusion was his analysis of distinctiveness, which, as we see, comprises a straightforward error. So this is a case like TVIS, where the judge's analysis of distinctive character has just gone wrong in the context of the likelihood of confusion assessment. Like in TVIS, the judge has been distracted by his impression of one element of the mark and his appraisal of that element's distinctiveness, when we know that the average consumer, and therefore the judge, must look at the mark as a whole, including at least all of the points of similarity in this analysis. So that's an error of approach, an error of logic, one might say, and this is therefore a case where you're justified in reversing the judge's finding. The judge will here then, as in that case, need to redo the global assessment, and as I've said, that was the only factor, the one the judge got wrong, in his analysis which he found pointed away. Redoing that assessment properly without the judge's error, I say it's clear there should have been found to be a likelihood of confusion as between the word marks. And I will deal with this now. It applies to the data findings too, but just a very short word about the German court judgment, what I do and what I don't take from it. So I note just in passing, I say this court can take comfort when you redo that assessment and reach that conclusion from the fact that the German court deciding the parallel dispute reached the same conclusion, namely that there was a likelihood of confusion between Athleta and Athlecia. I don't propose to take you to particular sections of it. That judgment plainly doesn't bind you in any way, nor did it the judge. And this court must make its decision based on the materials in this jurisdiction, of course. I just have one or two general submissions to make about it, and I say it can offer comfort in your reappraising that likelihood of confusion in the way that I urge you to do. That's because the German court is, of course, applying more or less the same trademark law, it coming from EU trademark law. There has been no relevant statutory amendment or departure in the case law in the UK since Brexit, and so the assessments are essentially the same, and I'm focusing on the legal analysis for this ground. In Germany, the same sorts of arguments were made, relying on the German word for athlete, Athlet, which is exactly the same as athlete without the terminal E. And the court still found the likelihood of confusion, as this judge should have done if he hadn't made the error that I've identified. Finally, there has been some back and forth in the skeletons about the position as to an appeal in Germany, so I just want to be clear about that. It is right that there has been no final decision by an appeal court in Germany. There is an appeal on foot, and what has happened is that the appeal court has issued a preliminary opinion and called for evidence on one narrow point. Its preliminary view is that the appeal court agrees with the assessment of infringement by the court below, subject to calling for some evidence from Athleta's Portuguese manufacturers for proof of use before issuing its final decision. So that's the position at the moment. Athleta succeeded at first instance, and the appeal court is currently inclined to agree with that analysis, subject simply to some materials on proof of use. For my Lord's notes, we've got the first instance judgment in translation at tab 2 of the supplemental bundle, and that preliminary view and call for evidence is at tab 4. I don't propose to turn those up because, as I say, I fully accept I get nothing more from them than that you can feel comfortable in reaching the assessment that I urge on you and would be urging on you absent that judgment too. It doesn't bind you and I don't seek to suggest it does. So, if it pleases, that's it for ground 3. And I propose to move to grounds 4 and 5.
Yes, thank you.
These two grounds are very closely related, so I'm going to take them together. They also go to the assessment of trademark infringement, but this time to comparing the respective combination, that is word plus figurative element, marks. Having taken you through the infringement analysis in the judgment in some detail and shown you the structure that the judge adopted for the word marks under ground 3, I hope to take a lot of that as read and just pick out relevant paragraphs when it comes to these grounds instead. I'm not seeking to island hop, but just for timing reasons I'll show you the bits that I rely on. The judge found infringement as between the pair of signs that are set out below his paragraph 162. So that's page 157 of the core bundle, behind tab 9.
Yeah.
So that's the Athleta combination mark and the Athlecia second combination, which is what we might call the inline one. But he found no infringement when the Athlecia roundel device, which he agreed, incidentally, was similar to the Athleta roundel device, when that roundel device was simply moved 90 degrees around the Athlecia word. He found that was so because it altered the distinctive character so much that it took it out of the realms of confusing similarity. That's his paragraph 164, shows the conclusion he arrives at, and the as set out above must refer back to paragraph 71, which I'll take you to, which is in the context of variant use. So I'm going to have to deal with it because the judge has cross-referred to assessment of alteration of distinctive character for variant use and then relied on that here for confusion. I'm going to have to do the same. So we're going to be hopping between his assessment of comparison of the marks and his assessment of variant use, but I'll try and be clear where we are when I do so. So 164, the judge says, as set out above, the placement of the roundel makes a difference. So I do not consider that there is a likelihood of confusion as between the Athleta combination and the first Athlecia combination, even for identical goods. Grounds 4 and 5 both go to what we say are errors in that assessment. Ground 4, I said that he sort of tackled this in respect of comparison of the marks and with respect to the distinctiveness assessment, so the grounds go to one of each. Ground 4 says that it's in error as a matter of the proper comparison of the marks, and then ground 5 says the judge was wrong when he based his finding of a material difference between the two roundel placements in the analysis of distinctive character. So ground 4, this is a relatively short point. I simply say that the judge's analysis of the comparison of the combination marks was illogical and inconsistent. The Athleta combination mark is the Athleta word mark plus its roundel. The first Athlecia combination mark is the Athlecia word mark plus its roundel. When considering visual similarity, the judge correctly concluded that the word elements, that is the Athleta word mark and the word Athlecia, were visually highly similar. And that's 115 in the judgment which we saw a few moments ago. In fact, let's turn it up because there are some findings in the following paragraph that I'll be looking at too. He also found that the textual element of the combination marks was similar in its presentation. That's 116. Then, 117. In the first sentence, the judge found that the addition of the roundel did not make a significant difference between the mark and the sign. The judge also found that the roundels themselves were sufficiently similar that the Athleta combination mark and the second Athlecia combination were highly similar. That's the third sentence of 117. And then towards the end of that paragraph, he made a finding that not just the addition, but the particular placement of the roundel would not make a significant difference, though it would make some difference. In my submission, this is inconsistent. First, we start with similarly presented word elements which are highly visually similar. We then bring into the analysis the roundel element, which the judge has said its addition and its placement make no significant difference. But then in the very same paragraph, effectively he finds the roundel does indeed make a significant difference, such that the similarity gets downgraded to medium. I'm going to say that sentence again because I fluffed it, excuse me. Then in the very same paragraph, he finds that the roundel does indeed make a significant difference, such that similarity gets downgraded to medium.
Isn't this just a question of the first instance judge forming an evaluation? Because again, reading that passage as a whole, he says, the difference in placement of the roundel will be appreciated by the reasonably circumspect consumer. I don't consider that it will make a significant difference, but it will make some. So that's the point he's making. It will make some difference. I therefore assess the similarity between those two signs as medium.
But, my lord, it is a matter for the judge's appraisal, of course it is. I can only succeed on this if he's approached it wrongly or inconsistently. I accept that. Why I say it's inconsistent is because he said that the presence and placement of the roundel are not significant.
Well, that I understand.
And yet they're the sole basis for a very significant change in a similarity analysis. And we know, because we've all seen the end, actually the vital change that meant that one of them infringed and the other one didn't is an element which he says its placement and its presence are not significant.
I see.
That's the inconsistency, my lord.
Right.
It can't both be insignificant and crucial. And in this paragraph, that same, both the presence and the movement of the roundel are said to be critical and insignificant.
Is it really the first sentence that you would place particular weight on at 117?
The first sentence is about the addition of it, yes, and then he says the same, then the penultimate sentence, the difference in placement of the roundel will be appreciated. I do not consider it will make a significant difference.
Yes.
So those are the two.
I see.
Is he making a distinction between the existence of the roundel and the position?
Indeed. I think the first sentence is about the existence, it's being somewhere, and the second time, it's about the placement, as in where.
So it's not quite as inconsistent as you're suggesting.
No, those aren't inconsistent with each other.
Right.
Those say both the addition of both the presence and the location are not significant. Those two sentences together, one of them addresses each.
Well, the second sentence says
Not a significant
not significance, but some. So he's saying there that it makes
a difference,
some difference.
Some difference that's not significant, and yet it's so.
Well, he clearly thinks it makes some difference in that passage.
Yes, an insignificant one, according to that sentence. That's the inconsistency I rely on. He says the presence in the first sentence, and in that penultimate sentence, the placement, are things that make no significant difference. Although I accept, and I've not sought to escape, he says some difference, but no significant difference. But in the end, he finds it to be so significant that it's determinative of infringement. That's inconsistent.
Yeah, that's your fundamental.
That's my submission on this ground. Yeah. It is a matter of appraisal for him that these sentences can't all be true at once. Can't be consistent with the conclusion he reached, and true at once. So, my lords, I say the proper approach on this ground is this. The judge found rightly that the respective word elements Athleta and Athlecia were highly similar, and that their stylisation was similar. The judge also found rightly, at 163, that in his judgment, the roundels are sufficiently similar, particularly taking into account imperfect recollection, as he must, that's right, to increase the likelihood of confusion. And the judge found at 117 that the placement of the roundels would not make a significant difference to the visual impression, though it clearly makes some difference. The oral and conceptual considerations, which still fall to be added in, yielded high similarity in respect of the word marks, are of course unchanged by whereabouts the roundel is. Those high similarities all remain. With all of those inputs, and bearing in mind the mandatory interdependency principle that we've referred to, in my submission it's clear that both first and second Athlecia combinations should have been found to be confusingly similar. The only relevant factor, aside from those other elements, of which the judge took account, was distinctiveness. And the relevant error in that regard is what I'll turn to on ground 5, which I move to next. But in my submission, these are not, they go together thematically, but they're not interdependent grounds. I can succeed on ground 4 on its own. I say it's simply inconsistent, and that's a reason to reverse him, to redo the assessment on the basis I've just set out. So ground 5. I've sought to show you how the judge's analysis was inconsistent when it came to the effect of the movement of the pinwheel as between the first and second combinations, considered through his assessment of the similarity of the marks. But he also erred when he considered the effect of that movement in the context of distinctiveness, which, as he correctly says, is another input into the likelihood of confusion assessment. So for this ground, we'll just start by going back to his conclusion at 164, which is on page 158. As set out above, the placement of the roundel makes a difference, so I do not consider that there's a likelihood of confusion as between the Athleta combination mark and the first Athlecia combination, even for identical goods. The set out above came, as I alluded to before, in the consideration of variant forms for the assessment of genuine use, and we'll need to go back, as we will in a moment, to paragraph 71 to find it. So this ground of appeal isn't one about genuine use and variance, but we are going to need to look at that part of the judge's analysis, because I think that's what he's referring back to here when he's considering the materiality of the placement of the roundel device.
Can you explain why you say that? Isn't it a reference back to 117 that we've just been looking at?
I'm trying to cover off both bases. It could be a reference back to 117, and in that case I'm covered by ground 4. The only other place he's considered the materiality of the movement is in the case of distinctiveness. So since he hasn't said which of those it is, and I don't criticise him for that, I want to cover both bases, which is why I've got ground 4 and ground 5. If he refers back to the paragraphs we've just been looking at, then you have my submissions. If it refers back to his assessment in the context of distinctiveness, then I say that also has an error, which is what I'm going to develop now under ground 5.
This is the distinctiveness of the mark that he's dealing with here. But you say it's logically the same point to you.
Yes, it's the distinctiveness of the mark. Yes, indeed, indeed.
But he's talking about the distinctiveness here, well, of a variant of the mark, isn't he?
Yes, that's right. I say it's logically the same, as my lord says.
Right.
I'll show you, as I say, that grounds 4 and 5 are the same point in essence. I'm attacking the same conclusion, depending on what it was that he was referring back to. So the judge considered use in variant forms, and he explained the effect of section 46.2 of the Trademarks Act correctly. You'll note that's at paragraph 42, but I can just put it very shortly. Genuine use of a registered mark can be made out by using a variant of the mark, where that variant doesn't alter the mark's distinctive character. Paragraph 70, the judge is thinking about the difference between the Athleta dark pinwheel and the combination mark, and he found that the dark pinwheel was a variant use of the combination mark because the difference, if it is noticed at all, would not alter the distinctive character. So it's inherent in this paragraph that the judge has proceeded on the basis that a variant could be noticeably different, but yet not in a way that changed the distinctive character. So in that paragraph, that's wrong. But then we get to paragraph 71. Now he's considering whether the Athleta purple pinwheel is such a variant of the combination mark, and he finds it's not, purely because of movement of the pinwheel, and that's why this is the other place that I think he might have been referring back to, and why I want to cover it off by ground 5. He says at 71, my findings are different in relation to the Athleta purple pinwheel. A mark registered in black and white encompasses use in any colour, and so the use in purple is not a relevant difference. If the use of purple were the only difference, that would be a difference that didn't alter the distinctive character of the mark. Correct, I say. That leaves the different placement of the pinwheel. And in this case, on the facts before me, I consider that to be a difference that does alter the distinctive character of the mark. For a reasonably circumspect consumer, the details of the roundel will, in my judgment, be less key. What will be key here is the word Athleta, because it's the only oral aspect of the mark and a key part of the visual aspect. The roundel will not be ignored, and its placement will strike the reasonably circumspect consumer. Thus, moving the pinwheel to be above the word does, in my judgment, alter the distinctive character of the mark. It will be noticed by consumers, who will notice that the purple pinwheel is not the same as the combination mark. So the judge's reasoning here is instead that the roundel will be noticed, it will strike them, and thus, as he says, that it alters the distinctive character. And that is the only other source that he could have been plugging in to the likelihood of confusion assessment when he comes to consider the movement of the pinwheel. My central submission in that respect is that the judge was wrong. It's an error of approach because the judge made his assessment as part of his appraisal in the distinctiveness of marks, where the appropriate question goes to whether the movement of the roundel alters the distinctive character through the eyes of the average consumer. And if it doesn't alter it, then following through to what he said at 164, you would think the distinctiveness part of the global likelihood of confusion assessment can be no less favourable to Athleta for the first combination than for the second, if there's no alteration in the distinctive character. But in my submission, even considered through the prism of variant use, the judge has wrongly abbreviated the question and changed the standard. It's clear from paragraph 71 that I just went through slowly, that the judge simply asked himself whether the change as between the first and second marks there, the movement of the pinwheel, was one that consumers would notice. That's not the right test. Certainly, it could work in reverse. If an alteration in the mark isn't even noticeable, then plainly it can't alter the distinctive character of the mark. If the average consumer can't even perceive the change, then he or she can't understand from it some changed message. That way around the analysis must work. But the way around that the judge appears to have used the test, merely asking if a change is noticeable in order to determine whether it's one that alters the distinctive character, doesn't correctly follow. And it certainly doesn't follow that the answer to the likelihood of confusion must be different simply because there is a change that is noticeable. The judge has effectively collapsed the analysis down to this. Because there's a difference that's noticeable between the two pinwheel placements, the variant ends up not being confusingly similar. And I say that doesn't follow correctly. So
you submit that noticing is not the right test. Is there any authority you rely on that supported that proposition?
Yes, I'm going to show you two where the change is plainly noticeable and was found not to change their distinctive character. The first is the GFK case. So that's at the Authorities Bundle 2, tab 4. This was an appeal from trademark opposition proceedings opposing registration of the word mark online bus. The opponent against registration relied upon the earlier mark that's set out at paragraph 5 of the General Court's judgment on page 171 of the bundle. And you see it's got the word bus and then Betreuungsverbund für Unternehmer und Selbstständige e.V. For that, the opponent relied upon, when the respondent to the opposition then put the opponent to proof that its mark was subject to genuine use, the earlier mark. And for that, the opponent relied upon the use of a variant form, and that's the one under paragraph 6, 171. you will see that the logo element moves between those two, from being above the word bus to appearing in line with it, and that longer text that I no doubt mangled a moment ago doesn't appear in the variant. That was challenged on the basis that it wasn't use of the right mark or a variant of it. So the question of whether it was a variant that altered the distinctive character was put in issue, and you can see that from paragraph 19 on page 175. Paragraphs 20 to 22 then set out the differences relied upon, which are the extra words, the long ones, the colour of the lettering and placement of the figurative element with respect to the word, and the colour of the figurative element. The court then considered this from paragraphs 33 to 41. It's fair to say it doesn't give much reasoning in relation to the figurative element by way of explanation, save that it's distinctive, like the roundel in our case was found to be. But the court reached the clear conclusion at 41 that even with all those changes together, the distinctive character had not altered. So what I take from this case, and this one is a pre-Brexit judgment of the General Court, is this. This is a case which shows that even a plainly noticeable change to a mark might be one that doesn't change the distinctive character. There's no application of the judge's noticeability test by the General Court, and indeed it would be all but unarguable to suggest that the differences between the mark and the variant under paragraphs 5 and 6 respectively are unnoticeable to an average consumer. And in that respect also, look at paragraph 38, please.
Is this just a decision on the facts? The
Well,
bits
this is an
you've just
appeal.
taken us to.
Well, I'm not urging on you that the conclusion must be the same because of their conclusion.
What's the principle? Sorry.
The principle is the one is that there is no application of the noticeability test, and I'm trying to show you this paragraph 38, which says, even assuming that the relevant public were to notice that it may also constitute an acronym, so that's the long text, its distinctive character is not affected by the removal of the explicative element. So they show here that it's right that a mark can be noticeably different, a variant can be noticeably different, and still not change the distinctive character. That's the principle, my lord.
If we go back to the core bundle, page 133,
4133.
yeah, which is paragraph 71 of
Yes.
the judgment which you showed us earlier.
Yes.
Again, don't we have to be careful not to take a single word out of its context? The 2 lines above the line you've been emphasising, the judge said its placement will strike the reasonably circumspect consumer. Now, if I were doing
Yes,
the exercise I say should not be done, I might place emphasis on the fact that, well, he's adopted a test of striking someone rather than simply noticing it.
That's fair, Mark. I was careful to read that sentence to you as well. I don't want to avoid it. The answer to your first question, my lord, is certainly yes. One must, of course, look at the analysis as a whole. I said to you I will just pick out the bits that I rely on because time doesn't allow me to go through every sentence.
I appreciate that.
But I would say that the test of striking the average consumer isn't right either.
I see.
Because those changes in the GFK case plainly strike the average consumer. They're huge by comparison with the present case, and yet they were found to be ones that didn't alter the distinctive character. So the principle the judge appears to have applied, that if they strike the consumer, then the distinctive character is changed, that's a wrong principle.
So what is the test he should have applied?
He should have asked himself whether it altered the distinctive character.
And you say, in substance, he was not doing it.
He's taken a shortcut by just saying, well, they'd notice it.
Yes.
Or alternatively, it would strike them.
Right.
So in that paragraph 38, the General Court was saying that even where the average consumer not only noticed the additional text, but noticed as well that it was the full text basis of the associated acronym in the sign, that wouldn't alter the distinctive character. So merely noticing or being struck by can't be the right test. That's what I draw from this one.
Yes.
So the second judgment is the one that my learned friend Dr. Darby referred to briefly earlier, So it's a post-Brexit case. I want to be careful about that. As a formal matter, of course, it's persuasive only. But of course, it's applying EU law that has in no material respect either been amended at statute level or departed from in the UK since Brexit. So in my submission, it is still a judgment this court should.
Is this the German record? Which case is this?
This is the LG Electronics
Yeah.
case at tab 5. It's the next tab along. What happened in this case was that LG applied to register the mark under paragraph 2. Tab 5, page 193, we're on, my lord.
Yeah.
So the mark sought to be registered is the one under paragraph 2. Anphalux then sought to have it invalidated, citing its earlier mark, which is the one under paragraph 6, just onto page 194. So like in this case, the earlier mark is in general form a word element comprising certain elements with meaning and a round figurative element on top. Once again, as you can see from paragraph 8, proof of use was requested in relation to the earlier mark. The question of variant use is decided by the court later on in the judgment at 87 to 92. And as 87 makes clear, the evidence submitted for proof of use showed use of the earlier mark, but with the figurative element situated not above, but to the left-hand side of the word element. So in that sense, the parallels with the present case are exact. But what I take from this is a submission as to approach, rather than just matching the facts. But what I say is one can't distinguish it and say, well, those are the approaches. That's the approach for this different sort of case, because the facts here are almost, well, they're not identical, but they're very similar. I first note in passing, because we'll need it for later on, the start of 89 on page 203, which concisely explains the rationale for having the variant use provision in the context of genuine use. The purpose of that provision, which avoids imposing strict conformity between the form of the EU mark as used and the form in which that mark was registered, is to allow its proprietor in the commercial exploitation of the sign to make variations, which without altering the distinctive character enable it to be better adapted to the marketing and promotion requirements of the goods or services concerned. So it's just about the realities of how people need to market things. If you have a brand, but you need to fit it to be an avatar for your social media page, or to fit on a swing tag that happens to be long and narrow that goes on clothing, or if there's some sort of dimensional requirement that requires a little bit of a reconfiguration of essentially the same brand, then you should be able to do that without all of your use and investment in your brand being counted back to zero. Just injecting some real-world consideration into this use idea. That's the purpose of this variant use provision. I put that on one side for now. We'll come back to it under ground 6. But what I rely on really for present purposes is what's in paragraph 90, that because of that logic of and rationale for the law of a variant use provision, it can't be the right that the distinctive character of the earlier mark was altered solely on the ground that the figurative element has been moved from being above the word element to the left. It's saying trivial changes like that, if you let that be a material change in distinctive character for this purpose, then you defeat the whole point of having these provisions there, of allowing these real-world changes that have to take place still to be counted as use of the mark. So I say that's exactly correct, as a consequence of the long-standing case law and the principles that underpin it. The whole purpose of variant use would be undermined if one couldn't simply move around the same set of distinctive elements within a mark as part of a refresh or a reconfiguration for use on the smartphone version of a website, or, perhaps more relevantly to this case, a physical clothing label or a swing tag.
So do you submit that what is said at paragraph 90 is more than simply a conclusion on the facts of that case?
Yes,
it does state a principle.
Yes, it's why I take you to this is to say that the conclusion was arrived at because it would be contrary to law otherwise. It comes from the purpose and the way that that part of the law exists, why it's there, what it's there for. Got to have that in mind, and the contrary conclusion will be contrary to that basic purpose. So it's clear that theirs wasn't just a reappraisal of facts, but it was a point that emerged from legal principle and the purpose behind that legal principle, very typically of an EU court, and from the case law that pertains in that respect too. So I say that even if we go back to the analysis under variant use, the second place where the judge has looked at the significance of movement of the roundel, his analysis there wasn't right either. So whichever of those it is that he was plugging in 164, I say there's a material error in either event. He was wrong, in summary, to find that the mere movement of the roundel between its two respective positions in the first and second Athlecia combinations was so significant as to be able to make the difference between infringement and not between the two Athlecia combination marks. And he got it wrong in those two contexts that go to these two grounds. First, when he inconsistently analysed the impact on similarity between the mark and the signs. And second, when he referred back to his findings in the context of alteration of distinctive character, where he applied too low a threshold that doesn't appear in the general court case law, and that the general court later case law makes clear the governing principle is one that wouldn't have allowed the assessment to proceed as he did. Unless I can assist you further, that concludes grounds 4 and 5 and leaves me with 6 and 7.
Thank you.
So that's it for trademark infringement. We're now on to passing off. 6 and 7 are distinct grounds from each other.
Just
Again,
to help me,
of course.
before you get on to the detail, can you enlighten us as to what your case is to the relationship between trademark infringement and passing off in this case overall? In most cases, not every case, but in most cases,
My Lord, I'm sorry, could you speak up
in
slightly?
most cases, one would expect the conclusion on passing off to mirror the conclusion on Section 10.2 infringement. If you are unsuccessful on trademark infringement, is it your submission that you can nevertheless succeed on passing off?
Yes, my Lord, there is a way in which that might be the case. It would depend why I didn't succeed on trademark infringement.
Right.
So the first thing to say is that my Lord is right, that often the two findings will follow one another. Of course, as my Lord also rightly says, they don't always. They didn't in my Lord's judgment in Skykick, they didn't in Comic Enterprises, and there are other examples. They have to be considered separately. If my Lord were to accept my learned friend's position in relation to my grounds 3 to 5, that notwithstanding that you might have sympathy with my submissions as to what the correct global assessment is, the judge didn't make an error of principle, so you can't reassess. But you were to agree with me that the judge has made an error of principle in relation to goodwill, so that passing off does need to be reassessed, then you could find for me on passing off, having found against me on trademark infringement, I think.
Okay.
It depends on the nature of my Lord's conclusions, I think, why the court decides what it decides. So I think that is open as a possibility, yes. Of course, my central submission is that they should follow each other, and we all know in what direction I say they should land. But it is right that they're considered distinctly, and there is, I think, a route in this appeal where my Lord could reach different conclusions. These two grounds are closely linked to each other, and I'm going to make them both in one go again, if it pleases. And indeed, I accept that I need to succeed on both, I think, to change the finding on passing off. If I'm right about the principle in ground 6, then I need the finding that I say under ground 7 should have been made about the extent of goodwill. So I propose to take each of these grounds a little more briefly than the trademarks one, so I'm hopeful that I will be within my estimate.
Yes.
I should firstly just deal with my learned friend's pleading point in his skeleton in relation to passing off. I can do so relatively briefly, because in my submission there's nothing in it for a very straightforward reason. My learned friend says that I have no appeal against paragraph 192, which is where the judge finds that there's no misrepresentation as between the word marks. And so he goes on to say, Because I have no appeal against that, even if I'm right about goodwill, it can't matter. Now, my first point is it would require a special sort of obtuseness to understand me to be appealing those findings on goodwill just academically and not saying passing off results should change. The skeleton's absolutely clear is that that's what I'm saying, that it should be reappraised. The three factors, goodwill, misrepresentation and damage, interrelate. And so if I'm right that there's an error of principle in relation to goodwill, then the court will need to revisit the passing off finding. But there's a stronger reason than that too. Let's look at paragraph 192. The judge says, I have found above. That is, in relation to trademark infringement, the likelihood of confusion, that the reasonably circumspect consumer of clothing, bags, etc. will not be confused as between the two word marks, including because of the weak distinctive character of each sign, and my findings on passing off are the same. So all he's done is cross-refer to his analysis of the likelihood of confusion. And all I will do is the same. I have my grounds against his findings on the likelihood of confusion, and if I succeed on my grounds 6 and 7, and you find there's a material error of principle so that passing off needs to be revisited, then very obviously I don't suggest you should redo the assessment with all the errors left in that I've told you about that were errors. So the short point here is, well, the judge cross-referred, and so should the court. The only reasoning here is the reasoning I've already spent an hour and a half of my Lord's time engaging with on misrepresentation. So I focus my submissions on goodwill. I won't need to deal with damage, because as the judge correctly records, in the last sentence of paragraph 193, damage was admitted to follow if there was misrepresentation going to protectable goodwill. That's usually the case, it's fair to say. My Lord Justice Arnold has commented in another case that it's very rare where there's a case where it can be said there's a misrepresentation but no damage, because damage can include factors like brand dilution and the inherent loss in control that you have if some customers think that somebody else is you, and they then are concerned about the quality of the service or goods that they receive, and you've got nothing you can do about that because it wasn't you. So I will focus have focused my grounds on goodwill, but you have my submissions in relation to misrepresentation already. I will make no additional arguments in relation to it. It's only the same things that I've already said, because that's all the judge did. So to ground 6 itself, the general structure of the tort of passing off was not controversial at trial, and I don't understand it to be so now. That law is well worn and hasn't recently changed. To put it briefly, the tort has 3 parts that I've already laid out: goodwill, misrep, and damage. That's recorded correctly by the judge at 171, and I don't propose to go to it. Passing off is, of course, not based on the trademark registration, but on pleaded signs and indicia in which Athleta said it had goodwill, having used them in trade. The judge correctly set out the signs that Athleta relied upon for this purpose right at the start of the judgment under his paragraph 5. We looked at those a little while ago. You turn to the assessment of goodwill for passing off at his paragraph 185, which is on page 163. And at 186, the judge finds that there is goodwill in the sign Athleta in relation to clothing. His reasoning for that is that the sales through John Lewis were enough to establish goodwill through use of that mark in trade. That being so, it was so much use that he didn't go on even to consider the other uses relied upon, because he'd already found sufficient goodwill on the basis of the John Lewis activities alone. At 187, still on the same page, he declines to find goodwill under the Athleta word mark in relation to the sale of bags. Then comes 188, where the judge considers goodwill in the use of the Athleta combination mark. My lords, could you read 188, please? My lords, my submission under this ground is straightforward and short. That last sentence of 188 is a statement of principle, and it's wrong. This alleged principle that whilst you can use a variant to establish genuine use for a trademark, you can't accrue goodwill through use of a variant, wasn't argued before the judge, and indeed the judge cites no authority for it. There is no basis in my submission for it in principle. We've seen, in the context of registered trademarks, the variant use provision and the rationale behind it, and I'm not going to repeat that. We saw it in the LG Electronics case expressed perhaps most clearly. In essence, it's just about trying to inject the trademark law with a dose of reality about how people actually trade and taking account of...
But that's based in a system which is all about registration and the rights conferred by registration, where you can register a mark which is totally unused, and you have 5 years in which to use it.
Yes.
And it's directed to preserving marks which have not actually been used in the form registered, but have been used in a variant form.
Yes, I don't say it's the same. I don't say that one should, because that provision of the Trademarks Act exists, it must apply to passing off. What I say is that the logic behind why that provision is there, which we saw in LG Electronics, that need for us to be practical and for goodwill not suddenly the counter to be set down to 0 because you've had to change the configuration of your mark to use it on a swing tag or something like that.
But I'm struggling to understand why you can simply translate the logic from one context to the other, because in the passing off context, the answer is straightforward, is it not? Which is that if you use a variant, then you got goodwill in the variant. And what's the problem with that?
The problem is when a business is conducted under a series of signs, or a series of variants of signs, and instead of asking what is the goodwill in the business and what signs does it apply to, one silos the assessment and says, well, what's the goodwill counter for this one, what's the goodwill counter for that one, what's the goodwill counter for the other. That's not the level at which goodwill properly is to be assessed in my submission. It's a property of a business, as the case law has established 120 years. It's an attractive force that brings people in. It's not a property of one sign. It's a business that uses certain signs. And so if, for example, one used a word mark, if one used a composite mark that has a word and a figurative element, that could plainly, I say, amount to building up goodwill in the name, for example. When the name is not the particular sign, the thing that's been used is the name with a particular figurative element, because people refer to the business as blah, even though it's always blah with a red dot next to it. So it's because the judge...
Well, that I can understand if the argument was, we claim goodwill in Athlecia. And then you can say, well, we claim goodwill which is accrued through various different uses of Athlecia on its own, in combination with the dark pinwheel, in combination with the purple pinwheel, and so on.
That's effectively the case that was wrong. Let me show you the pleading. Paragraph, tab 17 of the core bundle has the particulars of claim. It's not said in those terms, but in my submission the effect is the same. So it's page 206 behind tab 17.
I'm sorry, which page?
Page 206 behind tab 17 of the core bundle. It's paragraph 5 at the bottom. So further or alternatively, the claimant has generated and owns a substantial and valuable goodwill in the business, associated with the business of producing and selling those things under the signs set out above, that's the word mark and the combination mark, and or each of them and or the signs below. So I say what's pleaded is that there was goodwill in the business across this series of signs, all of which are indeed variants of one another. We didn't say it has goodwill in sign X Separately, it has goodwill in sign Y. Separately, it has goodwill in sign Z.
But I may be completely missing the point here. But you have a finding in your favour of goodwill in relation to the word Athlecia. And as you pointed out, there's no respondent's notice on that. So if the case is simply, well, we have more goodwill and Athlecia by virtue of use of Athlecia plus dark pinwheel or plus purple pinwheel, it adds nothing because you've already got a finding in your favour.
But I say that the same logic must apply when one says dark pinwheel plus the colour purple on the pinwheel as a variant of the dark pinwheel. Exactly along the logic of the sentence that my lord just put to me. I say that the purple pinwheel and the dark pinwheel are variants of one another. And so just as my lord says one could imbue the word mark with more goodwill through its use with those different variants, I say one can imbue the dark pinwheel, the purple pinwheel, through use of the dark pinwheel, which is the same thing with a different colour. Fundamentally, the judge considered the issue of goodwill sign by sign, and at a first stage, there's nothing wrong with that as a way to organise his thoughts, if I can put it that way. I don't criticise him for writing it that way. But his error was then to fail to stand back afterwards and consider the position in the round as a result of the totality of Athleta's business in the UK and the relationships between those different signs. By assessing the goodwill in isolated buckets according to each sign, and confining the entire analysis strictly by sign, or have they passed off this sign, have they passed off that sign, rather than by considering the business as a whole and what goodwill that trade has generated, that's why I say the judge fell into error. So I say that the use of the dark pinwheel amounts to the use of a particular variant of the combination mark. If the judge had considered it appropriately holistically at the level of what goodwill is there in this business associated with these related signs, in the way he should have, then he would have found that the uses of the dark pinwheel amounted to acts that contributed goodwill in the combination mark.
Is there any authority on this point either way?
I'm not aware of any, no. Neither of us has cited any. And the judge didn't either.
But you say your submission is consistent, at least, with the underlying concept of goodwill for the last more than 100 years.
Yes, and the fact that it's located with a business, and one doesn't ask is the passing off of a sign. It's passing off as against the goodwill, which is in the business as a whole.
And if that's right, then at least half of your pleaded paragraph 5 was completely irrelevant. Because what you should really have been saying is stopping after the third line when you said the business.
Stopping after, excuse me.
The first 3 lines of paragraph 5 on page 206 are making that point about the business.
Yes.
But the pleaded case, at least, was there was goodwill in and/or each of the signs depicted.
I think it's appropriate for the analysis has to be centred around some group of signs, related ones. So if we'd operated under 2 completely dissimilar signs, if I'd operated under the signs Stewart and Baron, and I had 2 completely separate ranges of goods that I relied on, and I said those were 2 totally different brands, goodwill in one wouldn't have any, because there's no interrelationship between the signs, it wouldn't have any effect on goodwill in the other. It's goodwill in the business it's the goodwill in the business conducted by reference to certain signs.
But if one is Baron and the other one is Stewart Baron, does that make a difference?
Yes, it might, because I might say they were variants, absolutely. And so that's why one has to plead the series of signs to say what the business is that you say has goodwill. It's the business defined by trade going on under a series of signs. What one doesn't do is ask, has there been passing off of sign X and passing off of sign Y and passing off of sign Z when those are variants of each other. It is possible for the same acts, the same trade, to imbue goodwill in more than one version, more than one variant. And the example that my Lord Justice Arnold gave a moment ago, for example.
So can we go back to paragraph 188?
188 of the judgment.
I just want to be clear what your submission on this point is. I may not have understood the submission correctly, which is why I'm asking you, but is it your submission that actually the judge embarked on the wrong exercise in the first 3 lines when he says, I'm unable to find goodwill in relation to the Athleta combination mark?
I say it was wrong to stop the analysis. As I said, it was perfectly permissible for him to organise his thoughts with respect to each sign, but then he had to stand back and consider the interrelationship between them, and that's what he failed to do. Because I say he has found in 189 that there is some use of the darkening wheel.
Yeah.
Ground 7 will say that should have been enough to be goodwill, and that's why I say I need ground 7 in order to succeed on ground 6.
I see.
So I think that concludes my submission on ground 6. Ground 7, finally, in my last 10 minutes. The starting point for this ground is the law that establishes that even a very small amount of trade can establish a goodwill for the purposes of passing off. It's very well established as a principle, and we've cited some of the law in our skeleton. I will take you through it, but very quickly, if I may.
Sorry, before you get into that, I'm still struggling to understand the analysis of this. I mean, let us assume, for the purposes of this argument, that you're successful on ground 7.
Yes.
So that there was sufficient
Goodwill in the darkening wheel.
goodwill in the dark pin wheel. Well, why can't you just rely on that sign? That goodwill as found in your passing off claim, because as you've demonstrated, it's within the scope of your pleading.
We can, or alternatively, I would say, so I say we can. Alternatively, I say it's a variant of the combination mark, so if you consider it, I say there shouldn't have been salami sliced between them, fundamentally. But my lord's absolutely right. If I got enough use of the darkening wheel, then I can succeed on that.
Right.
That must be right.
Right.
So, the central submission on ground 7 is to embrace the passage from Wadlow, at paragraph 246. It's in the authorities bundle at tab 7, but I'll just read it to you if I may, 'cause it's very short. For the claimant trading in England on his own account, even quite a small amount of business is sufficient to establish a goodwill. There may be sufficient goodwill even if the business has been intermittent, very recent in commencement, localised, or confined to a few customers. As well as that, there's his observation at 3142, also in that tab, that goodwill is normally created by trading and very slight trading activities have been held to suffice. Professor Wadlow goes on to suggest that even advertising in mere preparation for trading could suffice for a goodwill, but here we have more than that because we have substantial evidence of actual trade, as the judge correctly found, in relation to Athleta clothing sold through John Lewis, and that's his paragraph 186. Given what I say is the holistic nature of the passing off assessment about a business considered as a whole, there's no formula that emerges from the case law about a precise number of transactions, and that's unsurprising. But I do say it's appropriate to look to other cases to make good the proposition from Professor Wadlow that even small amounts of trading will do to generate a material, protectable goodwill. Since I've referred to them in my skeleton, I'm just going to sort of advert to them now rather than take you through them, if it pleases, with an eye on the time. The two well-worn examples that I don't propose to turn up. First, this was 3 weeks of use by a mobile fish and chip seller. That's the Standard Array case, and 1.5 months of advertising.
I'll just ask you this.
Yes.
Just to speed things up. Doesn't the judge set all this out at 174 and 175?
Yes, and then we say he didn't
He
decline.
refers, I guess you're about to go through to those cases which he refers to, is that right?
Yes, yeah, they're the same ones I showed him.
So he accepts this principle as a matter of law.
Yes, and then fails to apply it in my submission.
Right, so it's about the application of the principle.
Yes. I say when you look at his reasoning, it's the wrong conclusion. I'll show you some of the evidence. I'm not going to show you all of the evidence because there isn't time. But I'll show you some of the evidence and I'll say that it's not the right conclusion unless he was applying the quantitative minimum, but he shouldn't. It's not an available conclusion unless he was applying the wrong quantitative minimum.
So is it the submission that his conclusion was not reasonably open to him on the evidence before him?
It is, yeah. It wasn't on the evidence, unless I say the reason that he reached the conclusion that he did is he implicitly, as we'll see, applied a quantitative minimum to the assessment. So I've given you those two relatively well-known examples, and then perhaps something approaching more of a statement of principle emerges from the judgment of the High Court. That was Mr. Justice Whitford in Chelsea Man. That's tab 2 of the First Authorities bundle, and it was upheld on appeal, as I've noted in my skeleton. It was another case like the present about allegedly deceptive branding on retail clothing, and that, for your note, page 574 of the report, which is page 16 of the bundle, sales of this order considered on numbers of articles or cash value are of course very small if compared with sales made by a multiple concern operating through large numbers of retail outlets. And then a few lines later goes on to say, a trader operating through a small number of outlets selling articles of the quality described, and a number of other witnesses at relatively high prices as compared with the goods sold in multiples, is as much entitled to protect his brands and business name as a large concern. I also have referred in my skeleton to the Lumos and Sweet Squared case. I don't propose to take you to it because I wouldn't draw any more from it than I have in writing. Safe to say that the majority once again emphasise that even a limited business with limited goodwill can protect it by passing off, and the result of that was that the court reversed the judge below and found passing off even the basis of a small number of sales. So the principle I extract is simply the one that Professor Wadlow stated. My lords, I was going to look at some of the evidence in relation to the dark pinwheel use. With an eye on the time, I have got a list of the pages of the supplementary bundle that I was going to take you to. I propose to hand up the list, and I'm just going to show you one or two. I'll of course give my learned friends the list. It doesn't have any submissions on it, and I'm not going to, it's simply the list of things I would have walked through now if I had another 15 minutes. I see that my lords are mostly using hard copy bundles. It may be that in some cases it would be easier to see on the computer anyway because the images might be sharper. When we were looking at swing tags used in a display in a shop and so on, that may well be easier on the computer. So if we just turn up the first, so that this is use in two contexts, use in the John Lewis stores, and then use through the Athleta website, about which you've heard Dr. Darby's submissions in relation to targeting. So I say that the John Lewis stuff alone is good enough, not least because the judge himself found that there were sufficient John Lewis sales to make out goodwill in relation to clothing. He found that in relation to the word mark, and all I simply say about those evidence examples is that they show that actually those transactions were carried out by reference to the dark pinwheel as well. I'll show you one or two of those now, but I won't do all of them. So if we go to Supplemental Bundle 1, page 95 is the first. And so there are some photos from the Cheadle John Lewis and then from the White City John Lewis, so Manchester and London. On the first page, the Cheadle one. In the first photograph, about an inch down from the top, half in the middle, you can see the dark pinwheel being used there on the board that has all of the hangers underneath it. And if you go to the lower photograph, you've got the same. You can see the same board now in the top right, and in more or less the dead centre of the photo, you can see another Athleta sign with the dark pinwheel used there on the table. A close-up of the Athleta dark pinwheel in the middle of the sign in the third photograph, and then to White City in London, and one can see about an inch in from the left, halfway down, a little Athleta sign on the table there with the dark pinwheel on the White City photograph. So we're on page 96, my lord. This is White City, and about halfway down, an inch in from the left, there is the Athleta dark pinwheel on a sign on the table. If we go to page 100, I promise I'm not going to do all of this, I'm going to show you some of the different types of uses. One can see, and this is one that might be a lot easier on the computer, I suspect.
Yeah.
If one looks at the swing tags on those t-shirts there, they've all got the dark pinwheel on them.
And this is from where?
This is from, this was evidence that was before the judge. Whose evidence was it? Oh, sorry, are you asking me where in the sense of which witness statement it was in? Or...
No, which store?
Oh, I'm sorry, this is the White City John Lewis.
Right.
So this is in London again.
Yeah.
You can see that from the email on page 98.
I see. Right.
And then 103 is another example which has got the dark pinwheel on the table. And if one looks at 107, one can see another big sign in about the middle of the photo, just slightly above the middle of the photograph. Now, this isn't an exercise in counting the number of tickets. I said that there wasn't a quantitative minimum, and I meant it. The business is what falls to be considered, and the context here is that the presentations to customers in John Lewis stores, a popular national department store chain, and these are the examples from their stores in our two biggest cities. In my submission, this amounts to real use in the context of a serious business before real consumers. With clear, repeated and consistent use. Athleta, you've seen it, it's on the tables and on the shelf and on the thing on the back and on the swing tag. And I'm not sure whether it's fair to characterise this as a gap of logic or not, but I'll make the submission anyway, because as we saw under ground 6, the judge found that there was enough sale of clothing through John Lewis alone to amount to substantial goodwill in Athleta. There was enough of that, indeed, that he didn't even need to consider any of the other uses that we relied on to establish that goodwill. But the evidence I've shown you, and certainly the totality of it, the totality of the examples on the list that I've given you, demonstrates that in substantial part, at the very least, those sales of clothing were under the dark pinwheel, both on swing tags attached to specific items and signs over the display, on the walls, on the tables, at those stores. All in flagship large department stores in major cities. So the judge, having found that there was enough trade through John Lewis of our products to found a substantial goodwill in clothing, given the prominence of the dark pinwheel use in that very setting, he ought to have found there was also substantial use of the dark pinwheel. This evidence was before the judge, but it's not discussed or indeed mentioned in the judge's reasoning under goodwill. It would appear he's left it out of account. And I say that because I do say if he had included it, it wouldn't be available to him to say that this wasn't a serious attempt to create a market, sorry, a serious attempt to do business under this series of signs. So as to the consequence of my submissions on ground 6, well, let's look at paragraph 193 of the judgment. That's on 164 of the core bundle behind tab 9. The judge explains that if there were goodwill in the dark pinwheel and or in the Athleta combination, and I say he should have found that there was goodwill in one or both because of the evidence of the use of the dark pinwheel, he would have found misrepresentation and damage and therefore passing off. It's purely because of his finding there was no goodwill under the dark pinwheel that we didn't succeed. So if I'm right that he should have found goodwill in relation to the dark pinwheel and or the combination as a variant of the dark pinwheel, the finding of passing off follows. So I say in closing that the upshot of all of this is that if I'm right on these passing off grounds, the passing off assessment does need to be redone, as I said when I addressed the pleading point, because the three parts of the analysis interoperate, particularly the relationship between goodwill and misrepresentation. One needs to ask a misrepresentation in relation to what. And so if one has the wrong what because you did the goodwill assessment wrongly, then the passing off assessment needs to be redone. Given my submissions under grounds 3 to 5, there is a misrepresentation, just as there was a likelihood of confusion.
What, the misrepresentation would be by the defendants using what? Because he doesn't spell it out in this paragraph.
Right. I would say all of the accused signs are infringements and passing off. Each of them is sufficiently similar that they make a misrepresentation in relation to the dark pinwheel. I say the dark
Not just
pinwheel.
what he calls the device, presumably.
No, we didn't rely on the pinwheel device alone. We declaimed reliance on that as a sole element.
Right.
Below, and I don't seek to resurrect that now. No, that's very fair. I must be clear about that. There is no reliance on purely the device. So, in short, I say that there is
I'm sorry just to pursue this point. The judge has held that he didn't think there was confusion for the purposes of trademark.
Yes.
In relation to the first Athlecia combination.
Yes. I say the dark
And he
pinwheel
hasn't
is
spelt out here what the misrepresentation would be by the defendant. He just said there would be.
That's
The
true.
misrepresentation is described at 191.
And also in the middle of paragraph 193, the judge tells us what he would have found.
Yes, indeed.
Relevant
Yeah.
misrepresentations.
So it's clear that if I'm right about goodwill, then the judge would have found passing off, I say, on the basis of 193.
Yes, I accept that. I'm just wondering whether it's more limited than all of the signs, or whether it's all of them. He doesn't spell that out.
You're right that he doesn't spell that out. He does spell out at the start of the judgment which signs it was that we alleged were the basis of passing off, and we did allege them all, and he says he would have found passing off. I can't fill the gaps in any more than that, my lord, but no, the observation my lord makes is right. But I say we would have succeeded on passing off if I'm right about goodwill, and I say I'm plainly right about goodwill. On the face of these uses of the dark pinwheel in major department stores across the country.
Put it another way, you submit at paragraph 193, the judge was clearly stating that the only reason why you lost on this tort was his finding on goodwill.
Yes.
And you say,
And I say it's wrong.
That's wrong.
Yes.
I understand. Right.
And for the misrepresentation, I simply say, well, there we are, you've got my submissions in relation to grounds 3 to 5, I'm not going to repeat them. And I say that the dark pinwheel is a variant of the combination mark. So when he's assessed the combination mark in relation to trademark infringement.
Well, he does say he would have found misrepresentation in relation to the Athleta dark pinwheel.
He does.
But not the purple.
Yeah, if I'm right about goodwill, then I'm right about passing off, is the long and short of it.
Right, thank you.
And you have my submissions on goodwill. But my fundamental point is that you have to reassess this based on the material you've got. You've got those two plugins, and then goodwill, where I say he made a material error. My lords, unless I can assist you further,
My lord.
that's our case on this appeal.
No, that's very helpful. Thank you. Yes, Mr. Verhagen.
My Lords, I'm going to rather traditionally address it ground by ground, if I may. I'm going to start with the non-use ground, ground 1. And in relation to this, I want to look at 4 topics. Firstly, the context in which it arose. Secondly, the material law. Thirdly, the material facts. And then finally, the judgment. So in terms of context, the judge held that there was sufficient evidence of use in relation to clothing for the Athleta word mark and the Athleta combination mark. That was based on the evidence of use of the marks by reference to sales in the United Kingdom and in Europe of clothing under those marks, primarily through Border-Free and through the John Lewis website and John Lewis stores, such that the judge did not need to consider the US website i.e. the offers for sale and advertisements via the US website for these goods. And just for your note, for example, judgment paragraph 75, piece in judgment 95, John Lewis sales were alone sufficient to establish genuine use. Similarly, the judge found sufficient evidence of use of the Athleta word mark for bags and headgear from sales of those items in the UK through John Lewis, both in stores and from the John Lewis website evidence. That's the judgment 93 and 94 for bags and 96 to 97 for headgear. That meant again the judge did not need to rely on the US website use in respect of those goods for the word mark either. But the appellant did need to rely upon the use which could be gleaned from the US website to seek to establish genuine use in respect of the word mark for clothing, accessories and footwear, and the combination mark for clothing, accessories, footwear, bags and headgear. Now I appreciate just for the appeal now, they're not pursuing the word mark nor the combination mark for clothing, accessories and footwear, but they are pursuing the combination mark in relation to bags and headgear. Now this was because the appellant's evidence in relation to the use of those marks as a result of sales of those goods in the UK, under and by reference to those marks through Border-Free, Zalando or John Lewis, either in shops or in the John Lewis website, or any other route, was wholly inadequate to establish genuine use, or indeed any use. That's why the appellant needed to rely on evidence of use derived from what took place on the US-facing website as being the only possible basis for retaining the marks themselves for these specific goods. Now, to be absolutely clear, what the appellant was seeking to suggest from the US website is that it could be relied on as providing use by way of advertisements or offers for sale of the specific goods under the specific marks to the average consumer in the UK to justify a finding of genuine use. So they had to rely on the US website as representing offers for sale of the goods in question. And that's why when you look at paragraph 29 of the skeleton, they're relying on the examples from the website as being offers for sale. However, for a US website to constitute an offer for sale or an advertisement, the particular use of the trademark in relation to the good as an offer for sale or an advertisement has to be targeted to the UK. And the offer for sale or advertisement in question has not merely to be accessible because it's appeared on the website. Rather, as we know from lifestyle equities, it's necessary to look at the acts which are associated with the use of trademark and focus on them and ask whether those acts are targeted at the United Kingdom. What the judge did then was consider what was relied on by the appellant as evidence of the use, i.e. the alleged offers for sale and advertisements of the goods in question, and whether they were under the required marks, as they were said to appear on the US-directed website. The judge did that and held the evidence to be insufficient. There to be so little of it to amount to genuine use in relation to either mark for these additional categories of goods, whether or not that specific page would have been understood by a UK or EU customer or consumer to be targeted at them. That is the judge's ultimate decision at judgment 104. We better just remind ourselves what the judge said, which is why this whole targeting thing falls away completely, because at 104, page 139 of the court bundle, I consider in each case, this is his conclusions on proof of use, having reviewed all the evidence before the court, that these are fair specifications, i.e. he's already rejected the claimant's, appellant's arguments for use, having regard to use which has been made of the marks. I should add for completeness, my conclusions would have been the same had I included all of Athleta's variants as use of its marks and or included Athleta's US-facing websites as use of its marks. Now, he was correct to come to that conclusion, as I'm going to explain in a moment. But more importantly for the purpose of this appeal, he was entitled to come to that conclusion, even if this court, or any judge of this court, might on the same facts have come to a different conclusion, because this was a multifactorial decision which was not irrational, nor failed to take into account any material factor, nor whether otherwise involved any gap in logic or was inconsistent. Specifically, this was because there was insufficient evidence of an offer for sale or an advertisement in respect of such goods in respect of the marks in question. Cutting to the chase, at the highest, the evidence just demonstrated that certain pages of the US-facing website may have been accessible, not that those pages were in fact visited by any person from the UK and EU. Moreover, while some of those pages could at their highest be understood as offers for sale of certain goods, others could not, as no specific goods were identified at all on those web pages. Now, before I turn to the facts, I just need to remind the court of its decision in Easy Group and Nuclei, which we can see in the authorities bundle behind tab 7. And could I ask my Lord to pick it up at page 207, where this court sets out, through the hand of Lord Justice Arnold, the relevant principles law for non-use. Paragraph 105 at the bottom of page 207. These are the principles applicable to determining whether there's been genuine use. And my Lord then sets out all the core European cases. 106, ignoring the issues do not arise in the present case. My Lord sets out all of the key factors 1 through to 8 on the next page. And my Lord's aware of this must be more than merely token, must be consistent with the essential function. 5 must be by way of real commercial exploitation of the marks on the market for the relevant goods. 6, all relevant factors must be taken into account in determining whether there's real commercial exploitation, whether such use is warranted as in the economic sector concerned to maintain or create a share in the market. When you're looking at that, you've got to look at the nature of the goods, the characteristics of the market concerned, the scale and frequency of use of the mark, and the evidence that the proprietor is able to provide, and the territorial extent of the use. 7, not always be quantitatively significant to be genuine, even minimal use may qualify, as long as it's a genuine commercial justification. But it's also 8, it's not the case that every proven commercial use of the mark may automatically be deemed to constitute genuine use. And then 107 is also important to have in mind that this is a burden on the trademark proprietor, because the trademark proprietor knows what use he or she or they have made of the mark. They have to prove it. And the smaller the commercial volume of the exploitation mark, the more necessary it is for the proprietor to produce additional evidence to dispel any doubts as to the genuineness of the use. And the specific comments picked up by the court referring to Dan Alexander QC, sitting as the appointed person in awareness in Plymouth, are very pertinent in here, 19 and 22. If I can just ask my lords just to read that to yourselves. Clear and detailed, solid, not a case where you've got to speculate the burdens on the trademark proprietor to provide sufficiently solid and specific evidence to enable the evaluation of the scope of the protection which the proprietor is legitimately entitled and properly maintain, and that's only fair. So, of course, there's a statutory monopoly which gives them a monopoly across the board against all persons, not just simply the parties. By way of flavour, my lords, and this, I apologise if I'm directing this to my Lord Justice Singh and Lord Justice Miles, just by way of flavour, look at paragraph 108. These are where there's a quotation, a sub-quotation from the judge in that particular case. I'm just doing this by way of flavour so you get some understanding of the sort of numbers which are held, can be held, not to be genuine use. They're facts, and just by way of flavour. I'm not suggesting it's a point of principle, but you just get some of flavour. So, and then, may I turn over then to page 212, and pick it up at the bottom of the page, the appeal. Of course, as here, the judge assessment part of exercise in primary fact-finding and part of multifactorial evaluation, and then we know the standard tests if it's fact and so forth, which is set out at the top. And then application of the de minimis test 1, 2, 3. They contend that wrongly applied a de minimis test, sales and marketing. And again, I'd ask this court if it would be so kind just to read through 124 to 125. And because, as I'm sure this court is probably aware, having done a number of these trademark cases, this de minimis point is always run, usually when someone loses. But what the judge at trial has got to do is consider, well, what is the evidence they've actually got? And so as part of that exercise, you've got to sort of list out what you see in terms of use. So that by definition, there's also some sort of quantification. I see one sale or no sales. I see an example of a web page. But what the criticism is what the judge really found here was not a de minimis point at all. It's just a scarcity of evidence to show genuine use. And I'm going to show you why in a moment. He was entitled to come to that conclusion. And then the most important one for the purpose of today really is probably the 126 advertising. And here it's, if I can read this out, condensed that even if there was insufficient evidence of sales, the judge should have held the evidence of advertising, in particular by the Easy Office website, was sufficient to establish genuine use of trademarks. Now this was a website directed to the UK. There's no issue about targeting here. I do not accept this contention. There is no doubt that advertising constitutes use of a trademark. It's clear from the case law of the CJEU and the GCEU that advertising alone will rarely be sufficient to constitute genuine use of a trademark, although it can do in some cases. And in particular, this must be particularly so when the advertising consists solely of a website, even if the website is targeted at relevant territory. In the present case, the judge took such evidence there was advertising into account. In the case of the website, however, the Easy Group did not deduce any evidence as to the number of site visitors, let alone visitors from the UK or EU, or the numbers of page views. In those circumstances, the judge cannot be faulted for having given the existence of the website little weight. Jumping ahead, we say that applies in full terms to what was the evidence before this court in relation to the particular goods and the particular marks that my learned friend now wishes to rely on. But the reason that offers for sale on a website and or advertising it as appears on a website without more, and certainly without any sales derived from such offers for sale, is rarely sufficient to establish genuine use, include the fact that without information as to the viewing figures or hits on the particular website or particular web page, the court is given no real information as to whether the particular offer for sale is actually being made to any particular person or individual, or by any numbers, or by any individuals, or whether they're residing in the UK, or EU, or elsewhere. It's merely evidence that the website or web page was accessible, not that any relevant person in the UK ever saw it. And obviously, no, accessibility is not the same as meaning that there was even one effective offer for sale. The court's unable to ascertain whether any market share is being created, maintained or preserved by the use in question, or indeed whether, if any territorial use has been made of the mark at all. A website that is merely accessible by a person in the UK is not evidence that trademark propriety has actually caused any person in the relevant territory to see or act upon any offer for sale or any advertisement. Now, what the appellant is really complaining about here is that the judge failed to take into account and give any weight to the advertising use on the US-directed website. And we say, as Nuclei makes clear, even if there had been clear offers to supply under the mark for the goods in question, and the website was directed specifically to the UK, was targeting the UK, without any material evidence about the number of site visitors, number of page views, etc., a judge would be entitled to give it little weight to such evidence as evidence of genuine use. And that's what we say, in fact, has taken place here. So, what the judge did was consider the totality of the evidence. We've set out in Schedule 1 to our skeleton argument. This is not something that the appellants did. In Schedule 1 to our skeleton argument, we set out the totality of the evidence that was before the court in terms of genuine use in relation now to, we're just limited now as I understand, to bags and headgear. So that, if you go to our skeleton on page 24, we've set out the totality of all the evidence in relation to genuine use, potential to those two topics. Sorry, and this is, I'm referring to the amended one.
Yep.
To add a couple of additions which came in Friday night.
Yesterday, I think.
Friday, well, you probably got it yesterday, but it was sent Friday night.
Right.
I'm very grateful. Now, as we've summarised, the evidence was extremely scarce and thin indeed. It was simply not good enough for the court to find there had been genuine use. I no longer need to go through footwear and clothing accessories because they've been abandoned. But I do need to take you to headgear first. And that's in my note. Now, there's no use of the Athleta combination mark in relation to any specific item of headgear itself at all. Rather, the Athleta combination mark, or the variant, appears as part of the branding on the website. Insofar as the shoes, let me show you by way of example. So this is, let's look at Supplemental 2, tab 7, page 90, one of the ones my learned friend, I think, the Dr. Darby took you to.
Yeah.
So this is the use of this is claimed use of the Athleta combination mark in relation to headgear, and this is one of the web pages he relies on. It's SB2, page 90, 19th of January 2019, and you can see this is a US-facing website. There's free shipping and orders of more than $50 or more. The top banner you see at the top is that this is a multi-branded website. You have Gap, you had Old Navy, you have Banana Republic, then you had Athleta, that's the only combination use here. Then you have Hill City. And if you click on Athleta, you get Athleta as the word mark appearing at the top banner. You see there? And then if you click on shoes and accessories, you get what appears here. And they rely on this as being evidence of use in relation to headgear. And you will see that whilst on the left-hand side, when you see all accessory sale, all accessories have been clicked, you can see that on the left-hand side there is hats and headbands. On this page, you see no image at all of any hat or headband which is described by reference to the combination mark. But you do see a picture on the left-hand side of a Breeze reversible bucket cap. You see no picture of a knotted headband in using Power Sitter, I think, or Power Sitter. And so what you've got here is specific images and descriptions of headgear and other items for sale in the US dollars, all in the accessories sub-tab. None of those images or none of those descriptions use the Athleta combination mark at all. That is representative of all of the US website use that they are relying on in terms of headgear. Similarly, and look at that number, look at page 92 as well for the mole headgear, hats and headbands. You can see that, again, doesn't show use of the particular mark in relation to any hats at all, despite the fact you see hats and headbands at the top sub-banner on page 92. Similarly for bags, the same points apply, and they rely on the same evidence, same web page evidence to support that submission that the Athleta combination mark was used in relation to these. And you'll see on page 90, going back to it, there is a bag there. You can also see, if you click on the left-hand side under all accessories, you could click bags as well. But what is striking is, despite this being gap, they haven't hoped at any time, or haven't decided at any time, to lead any evidence before the court of what happens if you click on a bag tab, seeing a particular bag under and by reference to any Athleta combination mark. Nothing whatsoever. Is that a convenient moment, or I can go on for a few more minutes?
How are you doing for time?
I have just started, but I'm hoping that this topic I'm going to finish in the next 10 minutes. So maybe...
In that case, I think we'll rise now and resume at 2 o'clock.
I'm very grateful.
Court rise if able.